Greetings, and thank you again for tuning in to another episode here on the 0%. Today is February 3rd, 2023. I'm glad to be here to talk to you all. You can find us on patreon.com/the 0% if you'd like to engage in our course for freshmen, sophomores, junior, and senior to know the ins and outs of becoming an actual private person and how to operate within a foreign express trust for complete zero tax liability purposes only. That is the main goal, to have or to accomplish asset protection. All right, asset protection for generational wealth building is what you will find in those courses. You can give us a call at 888-899-2262 if you'd like to speak with us. Schedule a consultation, and we'd be happy to speak with you. Today, we're going to talk about why it's important to clear the presumption that we are 100% U.S. citizens as opposed to our trust controlling that entity. And we're also going to get into reducing the national public debt. If you guys haven't seen, on usdebtclock.org, and I'll go ahead and pull that up here, usdebtclock.org. They also have an app, and you can see where the current United States is when it comes to debt. We are well past the threshold of limitation that they're supposed to maintain the debt in. Here it says total U.S. national debt is over $31 trillion. That is outrageous. Now, what's important to note here, you see in this section, it says dollar to oil ratio. As of right now, it is $0 per barrel. Same thing, it is $0 per ounce for silver and 0 per ounce for gold. We have been talking for a long time now. You need to do as best as you can to get rid of your dollars out of the bank. We're already under a digital wallet system. We have Apple Wallet, Android Wallet, Apple Pay. All of these different things are transferring over to a digital system. Now, we don't know when this is going to completely go full scale, but you got to prepare for it. And we've also recommended life insurance policies. It's a good place to store your money instead of storing it in the bank accounts. Just recently, I think in New York, Bank of America, a few of their check holders just had mistakenly some fraudulent Zelle transactions from their accounts, $100, $700 gone, with no remedy as to where it's gone or when they're going to get it back. And that can happen instantly with any amount. Okay, so setting up your trust enterprise account was a big deal as well, because those EINs are set up under the laws of TEFRA. That is going to create a shield, but you can't really bank on that. These banks can do whatever they want. This is their accounts. It's theirs. It's their franchise. It's their association. So a life insurance policy is completely separate from the U.S. Stock Exchange, and that is a place where you can hold it. You can do withdrawals. You can do policy withdrawals whenever you need to. And I recommend at that point taking the dollars and going directly to transferring it into actual money, which is silver and gold. Please do that and keep it. Hold it for yourself. Do not hold any type of gold or silver certificates. Okay. So with that being said, I also want to say this. For all that have subscribed here and all that are continuously a part of Patreon, I want to thank you for the continued support as we study and show ourselves approved throughout the many successes we encounter. But first and foremost, I want to say again that all things provided by the 0% have been gathered through trial and error throughout the years from personal study and assistance from other teachers domestically here within North America and internationally. And that ranges from pastors, talk show hosts, Hebrew scholars, real estate investors such as Ron LeGrand, one of my favorites, prominent Armenian families, and more of a public hero, Jonah Bey, the noble Jonah Bey, which you can find him on his website, www.jonahbey.com, also on YouTube. I believe he's still on Blog Talk Radio, but he has a wealth of information that's inside of his archives, audio information. That may be hard to find, but it's there. And for good reason that it's set up that way to protect the information. But you can listen to it. It's available going all the way back until 2014 to the present day. Now, from all of the inspired guidance, it must be made clear that nothing presented on my end or from our organization's end is a direct copy from any of the above mentioned sources. Okay. All of the listeners know that I speak very, very highly of Jonah, always will, and I route people to his platform because we all learn differently. My words can't reach everyone. Noble Drew Ali's words can't reach everyone, nor can Jonah's words. And we learn different and we teach different. Now, he does provide templates on his site, jonahbey.com, but caution. Templates, they're made to be used a certain way, okay? Templates are a good rule of thumb for a guide, but never to be used as our own internal paperwork. And I've always been one to not plagiarize, which I recommend all of you to follow that same suit. You will never find any of the docs that I present to be an exact copy, not even remotely, of others that I have looked at as far as templates that are out there. Now, you may see templates out on scribd.com. You never want to take those documents and just send it out directly as is. You need to make it your own. You need to have your own understanding, see where it's coming from, and make changes and send out your own document. Because if you start to send out the very same documents that are out there or that you've purchased from someone, these organizations are going to know very well how to dispute you very easily. If they know that they're coming from one source, they can easily attack it. But if different express trust confederations are doing their own thing, then it's very hard for them to try and stop the process. So please do not plagiarize. I will not engage in that. It's very, very important if you want to move forward in this process. So I hope all of you do the same. By the way, the book, The 0%, which I enjoyed writing, it's a compilation of the true history of the United States. You can find it on Amazon.com. And like I said, it's a true compilation of the true history of the United States, what it was and how it came to be and what it is now, and understanding the difference from your title of nobility, your private person, and your ens legis, the subcorporation of the United States, as well as building credit or entering into real property consumption without taking on a mortgage. This is a really skilled trade that you can enter into called seller financing. Sometimes you can reach out to private lenders to do that, where they're not reporting on the actual social security number. But seller financing is the best way to obtain property without guaranteeing debt. It's something that I practice and I teach. So you want to definitely get into a system where you're not taking on a mortgage. Mortgage is, there's even the biblical treaties talk against that. But it's all fascinating information, which is detailed in the book. There's a great saying by Noble Drew Ali, which Jonah Bey, he quotes all the time. It's, there will be new Moors to come and do better than the former Moors. right? Many of you have heard that saying before. And I must say, Jonah is exactly that without question. He has definitely taken it to an entirely new level of information, definitely. And we must all do our part and walk in the same path, as every teacher cannot teach every student, right? It's highly impossible. You'll find many of his audios in the archives. You'll see he's learned from Tony King, he's learned from Dr. York and many others to get to where he is today. And he's continuing to study and study and study and show himself approved, and a big inspiration for all of us. Now, with all the hype going around with the IRS abolishment, which could happen any day now, and subjects surrounding it, such as tax restraining orders or injunctions, they are paramount. It's something that you definitely want to do for yourself and your loved ones. Whether you use Jonah's version or ours, it's important to do it and to reference specific treaties and laws that pre-exist all of us. That's a key point. All of these laws that are mentioned, they pre-exist all of us. So none of us can copyright public laws that predates us. None of us can do that. But we can copyright literary works, which is what we teach here within Patreon. So with that being said, I know some of you had some questions in regards to that. Let's get back to it. Like I said, we're going to talk about why it's important to clear the presumption that we are 100% US citizens, as opposed to our trust controlling that entity. Because remember, a US citizen is a vessel of the United States. So our trust, which is foreign to the jurisdiction of Washington, D.C., because number one, it's established outside of North America, right? And we also have a foreign trustee. Okay, if you guys need that service, we do offer that. But you definitely want to have a foreign trustee who's completely separate from the jurisdiction of Washington, D.C. They have no social, they have no green card, no I-10 number, no U.S. passport, no U.S. driver's license. All they are required to have at minimum or at maximum is a traveling or touring visa to come here for 6 months, and then they go back home, right? That's all that they're allowed to have. So if you have that person, then they qualify to be your trustee. If you don't have that person and you don't want to do the legwork to find that person, we can provide that service for you as well. So this debt clock is astronomical. It's out of this world. And as you see, it is just going up and up and up and up. And a lot of it is our fault. We don't realize how to reduce this. We want to put the power behind the man that's in Congress. We want to put our faith in the one that is going to institute new laws on our behalf. Why on earth would they do that when they can make as much as they're making, and we're the ones, the surety for those debts, for their spendings? Why on earth would they stop that? Why on earth would they tell you what to do to get out of it? So you need to understand what money is, what lawful money is. It is not just only subject to precious metals. Lawful money has always been in circulation, always been in circulation. There are two sides to that dollar bill, right? If you look at the very first, when they first started to issue things, or these notes, look at the language right here. It says redeemed in gold on demand at the United States Treasury, or in gold or lawful money at any Federal Reserve bank. That means you could take this $20 bill, walk into Chase, and get a $20 gold piece coin. That's what you can do with it. You can exchange it. But you can't do that these days because they removed the gold from the banks. And now they're circulating these. This note is legal tender for all debts, public and private. So now when you take this directly into the bank, they're going to give you what? More Federal Reserve notes. So they're going to give you cashier checks, or they're going to give you money orders, or they're going to give you certified checks, corporate checks, or whatever it may be. It's always going to be in the form of a draft. So you have a choice now. Like I said, this Federal Reserve note has two sides. On the private side, it's a Treasury note. On the public side, it is a Federal Reserve note, but they left the choice up to you. You have to convert it. That's your job, not theirs anymore. It's your job. So if you have this $5 bill, you are supposed to go to the local gold exchange, exchange this $5 bill for an equal amount in coin. The Treasury only has the power to to coin money, not print money, right? But they're printing it, leaving an open door with this Federal Reserve note, so that way they can get away from that clause. They're still operating within that clause because there's two sides to the dollar bill that we have in circulation today. So, or what you do is this. Now, the first part I just said is going to help you to actually maintain lawful money. You exchange it for gold and you save it at home. Put it in a safe. No one knows. Dig a hole in the backyard, concrete it, cement it, build a bunker, whatever you want to do. Do not hold certificates because those can be traded on the market. And if they lose money, you lose money. You need to read the fine print with the companies that are holding your certificates. So I want you to hold it. Hold your silver, hold your gold as much as you can. The only money that you're supposed to have in the bank is just enough to pay the bills, just enough to pay your employees, your businesses, keep that in operation, and keep the lights on, right? And all of the interest and sales tax that you pay, make sure you keep the receipts so that way at the end of the year, you can do the proper tax filings to get those monies back. That'll be issued directly to your trust. Okay. So the other thing that you need to do to reduce what's happening here every day. I mean, all of this is people buying houses. This is people using their social security card to buy an airline ticket and going through the TSA window. All of this is everything that we do in a day-to-day transaction. This is why it's rising. Cars, automobiles, business credit, credit cards, debit cards, gas stations, and just the circulation of the cash itself. When you get paid, let's say $9,000, you get paid $9,000 a month, and you deposit that into your bank account, you're doing this because all of the banks operate under fractional reserve lending. So they are creating additional money because you deposited money in there and you didn't put this specific language on your notes. Now, where is this coming from? This is coming from 12 USC 411. Let's read. Federal Reserve notes to be issued at the discretion of the Board of Governors of the Federal Reserve System for the purpose of making advances to Federal Reserve banks through Federal Reserve agents as hereinafter set forth and for no other purpose are authorized. The said notes shall be obligations. Shall be what? The said notes shall be obligations of the United States and shall be receivable by all national and member banks and Federal Reserve banks, and for all taxes, customs, and other public dues. They shall be redeemed in lawful money on demand at the Treasury Department of the United States in the city of Washington, the District of Columbia, or at any Federal Reserve bank. This is the language that was on that $20 bill. This means that it is two-sided or one-sided, might I add, one-sided. So you could trade in that bill for an actual gold piece or a silver piece or a gold certificate or a silver certificate at that time at that particular bank. Now that it's not on there, you need to take your dollar bills that says this note is legal tender for all debts, public and private. You need to take this, you go down to the post office, because the post office has a decree connected to the United States Treasury. The Treasury is the post office is your direct access to the Treasury. There's an account there directed to the Treasury. Go and get a money order. That routing number at the bottom of the money order is connected to the Treasury. Okay? Now, when you get it, let's say it's for $500. In the memo section, you're going to write, redeemed in lawful money on demand at the Treasury Department of the United States in the city of Washington, District of Columbia, or at any Federal Reserve Bank. And yes, you can fit all of that on there. Write that on there. So by the time you give it to whoever you're making it payable to, they must deposit it. And by the time it gets to the bank, they cannot do fractional reserve lending anymore. This activity starts to reduce. If all of us can come together and do such a thing with every transaction, every purchase, we will have what's called a reduction in everyday sales and services and goods. You want to reduce gas prices, you do this. You want to reduce the cost of food on the shelf at the grocery store, you do this. You want to reduce a Honda Accord is almost $40,000, or it practically is right now with all the taxes and everything out the door. You want to change that? You do this. Circulate all of this. Stop using the credit cards and the debit cards. You can't really put that information on that transaction. Use lawful money, use the money orders. Even on your checks, you do the same thing. Cashier checks do the same thing. In fact, you can actually go down to the bank and have them put it on there for you. They'll type it in. All right? Take it down to Walmart. They will cash it and give you the difference. You take that cash and you do it again. You must start circulating these notes in the form of checks, money orders, cashier checks. That's what you're supposed to do. Now, where is this coming from? This actually comes from the Federal Reserve. There's an actual case. Federal Reserve website from the Board of Governors. They're answering the question, what is lawful money? Because there was a case where an individual was trying to exchange a $50 piece or a $50 bill for actual gold and silver, and the Federal Reserve wouldn't give it to him. So he's thinking, wait, you guys have just committed treason. Well, let's see what they say. It says here, lawful money is a term used in the Federal Reserve Act, the act that authorizes the Board of Governors of the Federal Reserve System to issue Federal Reserve notes. The act states that Federal Reserve notes shall be obligations of the United States and shall be receivable by all national and member banks and Federal Reserve banks, and for all taxes, customs, and other public dues. Where did they get that from? We just read it. 12 U.S.C. 411. Okay? They shall be redeemed in lawful money on demand at the Treasury Department of the United States in the city of Washington, District of Columbia, or at any Federal Reserve Bank. The act did not, however, define the term lawful money. But up until 1913, the only currency issued by the United States that was legally recognized as lawful money was various issues of demand notes, subsequently known as old demand notes, and United States notes authorized by Congress during the Civil War. At the time, some currency was not considered legal tender, although it could be used by national banking associations as lawful money reserves. Thus, the term lawful money had a broader meaning than the term legal tender. In 1933, Congress changed the law so that all U.S. coins and currency, including Federal Reserve notes, regardless of when issued, constitutes legal tender for all purposes. Federal and state courts since then have repeatedly held that Federal Reserve notes are also lawful money. Look at Malam versus U.S. 524 F2D 629 9th Circuit of 1974. Is typical of the federal and state court cases holding that Federal Reserve notes are lawful money. I'll say that again. Is typical of the federal and state court cases holding that Federal Reserve notes are lawful money. Now, you know how when you fill out your quitclaim deed or you're doing a deed to purchase a house, and they always state that the lawful consideration or valuable consideration is just $10. There's a reason why they keep it at $10. At $10, you can't have a trial by jury. At 21, you can. At 21 Federal Reserve notes, which is lawful money, at $21 you can, but $10 you cannot. So going forward on your quitclaim deeds, if you're not going to use actual silver dollar coins, and you're just going to use $20 or whatever amount in Federal Reserve notes, it needs to be at least 21 and up, but I would not go over 100. Now, if you do coins and silver, of course, coin is a higher value than the value of a dollar bill. Okay, so that's different. In Malam, the United States Court of Appeals for the 9th Circuit reviewed a judgment denying relief to an individual who sought to redeem a $50 Federal Reserve banknote in lawful money. The United States tendered Malam $50 in Federal Reserve notes, but Malam refused the notes, asserting that lawful money must be gold and silver. The 9th Circuit noting that this matter had been put to rest by the U.S. Supreme Court nearly a century before in the legal tender cases Juilliard versus Greenman, 110 U.S. 421, 1884, and it rejected this assertion as frivolous and affirmed the judgment. So Malam did not get $50 in gold or silver. He gave a $50 bill and they gave him back $51 bills, most likely. They just gave it back to him, said, we're here, we're giving you lawful money. He didn't understand that there was a dual nature to the Federal Reserve note. And they're not going to tell him that. They don't have to. They figure if you use a dollar bill, you are proficient in law and you understand how to use it. They don't have to provide the education on what they write. That is up to you to figure it out, right? Every man has the right to his own counsel. So We can all reduce the national public debt. Now that you know there are two sides to the dollar bill, don't just accept it as is and use it as is. Accept it, convert it into lawful money by purchasing cashier checks, money orders, or your own checkbooks, and make sure you write this language in the memo section. Now you have just entered into the economy a massive wave of an attempt to reduce the national public debt. That is the only way you can expunge it. With every dollar bill that's printed by the Treasury, there is interest attached to it. Okay, so if this let's say it's a $1 bill. If they printed $1 bill and there is, let's say, 90 cents of interest on it, that means the Treasury has to pay back that dollar plus 90 cents to pay it off. Where are they going to get the 90 cents if the Treasury is the one printing it and adding the interest? Where are they going to get it from? It's impossible. It is impossible. That is why this is happening right here. Okay, so the only way to expunge it is to reduce the principal by offering actual lawful money with this language on there. You have to start purchasing your goods and services with these, and this will reduce. But it has to happen as a wave. Millions of us can do this. It's so simple. The power has always been left in the people's hands. We elect other folks in certain positions constitutionally, but they're not going to do the job for us. We have to monitor them. They are the trustees. We are the beneficiaries. We tell them what they're going to do, not the other way around. Okay, you have to know that. You have to believe that. Now, I want to go into the U.S. citizen thing, because I talked about, we're going to talk about that. It is presumed that you are a U.S. citizen. You were born in, let's say, Iowa, right? Now, Iowa has ceded over their jurisdiction to Washington, D.C., and therefore has removed themselves from the territory of Iowa, the country of Iowa, to now being recognized as the state of Iowa. And you have a birth certificate that says the state of Iowa, right? You will always be an Iowan national. You will always be an Iowan national. Here's why. The birth certificate is a contract, okay? And you cannot enter into a contract without legal consent. You were an infant when that contract was created, and no other person can enter you into a contract on your behalf. Not even your mother, not even your father, not even your legal guardian. They went down, they applied for a birth certificate, and the United States illegally allowed it. That is what you call legal disability. This is illegal. So on the face, you are not a U.S. citizen by that birth certificate. However, that birth certificate evidences that you are a national in that country where you were born. There are 50 countries in this continent of North America. If you were born in Louisiana, you are a Louisianian. I myself, a Californian, or you can be a New Mexican. Those are nationalities. So, the U.S. citizen has been under what's called powers by the president whenever he declares a state of emergency. And we have been in a state of emergency for a very, very, very long time. Even though we think that the world is going great and there's no wars happening, we're still in a state of emergency. Why do they do that? So that all American citizens can be claimed enemies of the state under the Trading with the Enemy Act. All American citizens or presumed U.S. citizens are considered enemies of the state. And they have given guidelines and procedures and policies on how enemies of the state will be conducted here in the United States. So you're presumed to be a U.S. citizen if you keep on using their benefits and privileges, such as that Social Security number. Now, if you need to use it at this point in time, then you got to use it, right? But you want to build up business credit to where you can get away from that. And you want to build it up so strong that you don't have to use a personal guarantor with your business credit. If that's the case, there are plenty of employees out there who will want to take on that role for you. There are plenty of people that don't want to do this process. Unfortunately, a lot of them work for companies. And those are the ones that have been enslaved into that way of thinking that want to be an employee forever. Well, fine, I got a job for you. You can apply and get credit for this for one of my companies, and I'll pay you a certain amount of money for it. This is the commerce that Walmart does. This is the commerce that Walgreens does, McDonald's, Subway, all of the big ones, Microsoft, Nintendo, all of them. This is what they do because they know that there will always be slaves. You're going to have to go into the same business, come out of being a slave, start your own business, and you will have to hire some slaves. And they will always be there. They will always disagree with what we're talking about here. And that's okay. There will be two sides to everything. So when you go and look at what's called Senate report, this is 93-549. This is dealing with the emergency powers. I'm going to go down to page 3, and you'll see exactly what I mean. Here we go. Since March 9th, 1933, the United States has been in a state of declared national emergency. In fact, there are now in effect 4 presidentially proclaimed states of national emergency. In addition to the national emergency declared by President Roosevelt in 1933, there are also the national emergency proclaimed by President Truman on December 16, 1950, during the Korean conflict, and the states of national emergency declared by President Nixon on March 23, 1970, and August 15, 1971. These proclamations give force to 470 provisions of federal law. These hundreds of statutes delegate to the president extraordinary powers ordinarily exercised by the Congress, which affect the lives of American citizens in a host of all-encompassing matters. This vast range of powers, taken together, confer enough authority to rule the country without reference to normal constitutional processes. Under the powers delegated by the statutes, the president may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel, and in a plethora of particular ways, control the lives of all American citizens. If you are presumed to be an American citizen, your life is in the hands of whatever the president declares. And look how well they have done that with, you know what, C-19. Look how well they have restricted travel and instituted vaccine passports. By the way, if you do need that, we can obtain that privately. Okay, so they are seeking to control the herds. You're in populated areas, they control that, and you're being presumed to be an American citizen because you're not competent in their world. In their world, you have not been proven to be competent to handle your own affairs of your estate. So this is the process why we do what we do as what we teach in the Patreon courses. Okay, you have to get your estate and your affairs in order and place that all into your trust. Everything into the trust. If you're married, I do not recommend two separate trusts. One trust for a married couple. I recommend husband has his trust, wife has her trust, especially if there's children, right? The two of them will then create a third trust, which is the family trust. That family trust will then have two beneficiaries. Husband's trust as the first beneficiary, wife's trust as the second beneficiary. When it comes to the children, there's a certain process that you need to do with that. A certain process. Number one, up until they're 18, they belong to you. They don't belong to the state. Now you have to fix that because when they're born with birth certificates and they have social security numbers, the state has them, right? And they're considered wards of the state. So if you want to control your family and not give that jurisdiction over to the state, they're looking for an actual agreement, a contract that says who the children belong to. This is where we get into putting together a lease agreement for your child's estate. So if you obtain both of your child's estate, you're going to put together a lease agreement which says that the family trust is the owner in this lease agreement. Father and mother are the lessors, and the children are the lessees. And you can reference that on your non-UCC, which is recorded down in the county first. This lease agreement needs to first be put together holding your children's authenticated birth certificates, which is authenticated on every level of government and expressed by an affidavit of ownership. But the ownership is the lease agreement because the child is under 18. They cannot say the very same things that an adult would say under Rule 220. Okay, so it's a little different process when it comes to children and doing the proper paperwork so that the courts can properly respect the parents and their property. So that is inside of the course. We show you how to do that. All right, so if you see, they're trying to control all citizens here. And what you have to understand is just like the dollar bill has two sides, a public and a private, so do you. You have a public and a private. The private side, we like to look at that as your title of nobility, which is based by your nationality. Title of nobility is terms and phrases that people went by before the rediscovery of the 17th century. Nowadays, not so many people use that unless it's common in other countries like in Britain and other countries. But you want to go back to that and claim that that is your name. You need to declare that under a name change procedure with the court. And inside of that decree, with the court, it's going to show your true nationality as well. So you have the name change and the nationality, and that's going to reflect who you are on the private side. You can build business credit on the private side by obtaining an unincorporated association EIN number and build business credit on it. Right? On the public side, you have your regular birth name. You were born here. You have your social security number attached to it. You've been using it. You didn't know that you weren't supposed to use it, but you've been using it as old age insurance. And now you need to place all of that, which is your estate, into your trust so that everything that comes before or after the trust can now speak on its behalf. right? When you go to court and it's you versus the state, they always say you need representation. Why? Because your ens legis, your juristic person, can't stand on its own. It needs someone else to speak on its behalf. And so that rule of thumb translates into your paperwork as well. You have to have something else speak on its behalf, which is going to be the trust. The trust will claim it and claim everything that's in it for tax exemption. All right. So, like I said here, this is what they're doing, and you want to make sure you do a process to get out of it. Now, a little bit more on debt. Let's talk about mortgages. How do we get rid of these mortgages? What's the process? What are we supposed to be doing? You need to know that with a mortgage, everything in commerce is related to insurance, an insurance claim, everything. Even your insurance for your automobile, for the house, even that's backed up by insurance claims because it's bonded. But with mortgages, the note is insured. It's all about insured notes. And what backs up the insurance on it is a pool of investors who bring in the money. So if you were to default on your mortgage, the insurance company would pay it off. And who are they going to pay? They have to pay the investors. So whenever you do a process as far as, you're being foreclosed on, or you do bankruptcy and you need to make payments, guess who needs to get paid? It would be that insurance company. Okay. You're going to have insurance on your mortgage, whether you pay 20% or not. If you pay less than 20%, they're going to put a second insurance on there, which is mortgage insurance. Once you reach that 20%, you're not going to have mortgage insurance, but you still have to have insurance on the entire note. All they care about are the premiums paid on that insurance note, which is what you're paying every month. You're paying insurance premiums as a tenant. And as long as you make those premium payments, you can have what's called tenancy in commons ownership. That's what they call home ownership these days if you have a mortgage. You're making premium payments. You're not paying towards ownership, real ownership of a Lodio title. You're not paying towards that. You got to get rid of it. So if you have a mortgage and you didn't know that there was a certain thing that you needed to do at the closing table, all you got to do is refinance, and then you do what I'm about to tell you. All right. So let's look at the law. We go to servicing of insured notes outstanding with investors. Now, preface, we already talked about these notes are what? The obligations of the United States, not just Federal Reserve notes, right? Not just the dollar bills, all notes, mortgage notes, bond notes, all of those are obligations of the United States. So knowing that, now you have that preface in your back of your mind. Now you can read this with clarity. Now this is talking about the servicing of insured notes outstanding with investors. Let's go down to, we're going to go to, which part of it? Right here. We're going to go to C. So when you're at the closing table, there are three parties. There's the bank, there's the escrow agent, sometimes an attorney, and then there's you. This is the circuit. Money is coming directly from the United States Treasury, and it's being wired down to the bank. If you bought a $100,000 house, $1 million is wired to the bank based on fractional reserve lending. 100,000 will go to the escrow account and then given to the actual seller. The remaining 900,000 of credit stays with the bank because the banks cannot issue their own capital. They cannot issue their own capital from their vaults to loan to you. They can't do that. That is against the National Bank Act of 1863. Okay? Where did the money come from? The money came from you as the authorized representative, as the subcorporation of the United States corporation business. It came from you on that 1003 application. They got paid from the application, not the note. The application was the first form of payment. That was the check. You signed it as an authorized representative, but you didn't know that. And you said, I'm applying for this much, and here's my signature, here's my social security number. Yeah, it got to the Treasury, money came out of it, it's printed out or comes back in zeros and ones back to the bank. 100,000 goes to escrow, and here you are at the table about to sign the deed and the note to pay back, not just that 100,000, but the $1 million, right? But in actuality, it's going to be double to you. You're going to end up paying 200,000 over the course of 30 years. That's what's happening. Now, that money coming back to you is an obligation of the United States. So the circuit means you have to complete that circuit and send it back to them instantly. The money came to you at the table, it goes to the seller. Now that is an obligation of the United States, so you must send it back to them. So what are you supposed to do? On every page that you're signing for your mortgage or your deed and your note, you're going to tell the attorney or the escrow agent to tell you exactly where you need to sign off. And on the front of it, you're going to write, accepted for honor, on every page, accepted for honor. Then you're going to flip it over, and it's going to say, pay to the order of the United States of America without recourse on the back. What is that? That is what's called an accepted super protest. So if you look here in subsection C, assignment of insured notes to rural development, some of you may have an FHA loan, right? Or an agriculture department loan. So this is all going towards the rural development. Number one says assignment at the request of the holder. So at the closing table, you are currently the holder of the note and the deed right now. For assignment of an insured note to rural development during the option period at the request of the holder, the following procedure will apply. The holder will endorse the insured note as follows. Pay to the order of the United States of America without recourse. You see, I didn't just make that up. They're telling you to do it. The holder will then deliver the endorsed note together with the insurance agreement to the Director of Finance office. Do you see that? That's what's going to happen. Everything is connected to an insurance agreement. When it comes to your mortgage, when it comes to even getting a car, you do the very same thing. So like I said, on the front, you write accepted for honor, flip it over, and you write exactly what it says here. Paid to the order of the United States of America without recourse. Flip it over, go to page 2. Sign where they tell you to sign, you flip it over, pay to the blah, 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 blah. Now it's probably easier for you to do this by simply telling the escrow agent or the attorney, please mark off everywhere that I need to sign, and they'll do that. They'll tell you, here's an X, sign right here. And then you simply tell them, look, I need to read over all of this. Can you give me some privacy? They'll leave and they'll give you a couple of minutes and you do it. So that's what's going to happen. Now, you can do this exactly for a mortgage. And if you've done this in the past, you already have a mortgage, what do? Well, you just refinance. You refinance and you try it, and you do it then. What's going to happen is your very first payment, you need to proceed with accord and satisfaction. All payments need to proceed by accord and satisfaction. So after you've done this, you sign the front and the back, you make copies for yourself. It might have been very, very hard to get this to go through with the attorney or the escrow agent, but it's a federal crime for them to rip it up and start all over again. And they can't do anything against you once you've done it. You just simply say, look, I'm not an attorney. Maybe you need to go ahead and seek an attorney to see exactly how you need to proceed here and move forward here. But you need to just give me my copy and I'll be on my way. And that's it. They have to accept it and turn it in. So at that point, your payment's coming up. They're expecting you to make that payment. So make the payment using accord and satisfaction method according to your state. You want to know how to do that? Come into the classes and we'll show you how to do that, what that looks like. But it's very, very simple. The reason why you want to do that, accord and satisfaction, because that means if they still continue to ask you to make your payments, even though you've wrote paid to the order of on the back and accepted for honor on the front, you've just given the money back to them. It's now their obligation. And it's also considered a breach of contract for them to continuously ask you to pay when it should be paid by the Treasury now. It's on them. It is their obligation to begin with. So they're going to pay it. If they don't, close it out or refund you the money, now you have the right to open up an equity suit against the bank. And you may sue them for double the amount of the face value of the note, and you will win. Okay, there are several case laws that we have managed to scramble up from the archives that are going all the way back to the 1800s that talk about bona fide disputes and accord and satisfaction payments. And let's just look up, for example, let's just go to Florida. Go to Florida, accord and satisfaction. Right? Every state has it. It's stemming from the Uniform Commercial Code, Article 3, 311. And when you pull it up in your state, you're going to see similar numbers like that. In Florida, it's 673.311 or 3111. So it will be very close to that. So here we go. It says, if a person against whom a claim is asserted proves that the person in good faith tendered an instrument to the claimant as full satisfaction of the claim, that the amount of the claim was unliquidated or subject to a bona fide dispute, and that the claimant obtained payment of the instrument, the following subsections will apply. It says this: the claim is discharged if the person against whom the claim is asserted proves that the instrument or an accompanying written communication contained a conspicuous statement to the effect that the instrument was tendered as full satisfaction of the claim. Now, they have an out. They have an out. Right here it says the claimant, whether or not an organization proves that within 90 days after payment of the instrument, the claimant tendered repayment of the amount of the instrument to the person against whom the claim is asserted. So if you give an accord and satisfaction payment of $1,200, that's your monthly payment, and within a 90-day window, they refund it back to you, they can opt out of this accord and satisfaction. However, they can't do it if they've already been given payment, and that payment was the reassigning of your note when you provided that language, paid to the order of United States, right? When you reassigned it back to them, that was payment already. So your accord and satisfaction payment is simply just an opportunity to cure, so that way they can avoid being sued for double the face value of the note. But indeed, they're going to be sued and you will win. Talk about getting your house for free and getting paid for free. See, you're getting what's called your equity, your estate. Why? Because they utilize that estate, hypothecated it, doubled it, tripled it, sometimes times 10, and they didn't give you full disclosure that they were going to do that. That's why you sue them. Now let's go to 50 USC. This is 50 USC 4305, but of course we never put any of these terms in our paperwork. These codes here are copyrighted by them. So what you want to do is go all the way to the bottom if you quote any of this law, and these are the actual laws that you use. You have to pull up the public laws, 40 stat, and all of that. That's how you get away from them taking advantage of you in your court case. So in this section, you go down to number 2 right here. Now this is the result of what you've just done. Any payment, conveyance, transfer, assignment, or delivery of property or interest therein made to or for the account of the United States, or as otherwise directed pursuant to this subdivision, or any rule, regulation, instruction, or direction issued hereunder shall to the extent thereof be a full acquittance and discharge for all purposes of the obligations of the person making the same. And no person shall be held liable in any court for or in respect to anything done or omitted in good faith in connection with the administration of, or in pursuance of, and in reliance on this subdivision, or any rule, regulation, instruction, or direction issued hereunder. Do you see that? You put paid to the order of the United States of America without recourse on the back of the note. Now, the only obstacle that you have here is getting through that gatekeeper. Just like when we do the passports, the gatekeeper is that county clerk, or sometimes if you go down to the post office, the employee, right? They look at your paperwork and say, why are you doing this? No, you can't do this. Well, yes, you can do. And I'm just following the law. So you're dealing with peons, you're dealing with highly educated people who are misinformed, actually. And it's unfortunate, but these are the people that you have to get through. And if you can get through that gatekeeper, you have successfully done an amazing process for yourself when it comes to mortgages and when it comes to cars. So we went a bit long today. That's okay. I hope you learned something edifying for yourself today. Please pass it along. Once again, give us a call, 888-899-2262 if you'd like to have a conversation about any of the things that we discussed in this message. And I will see you in the next video or on Patreon for our live Q&A questions and answers on Saturday. Thanks again. You guys take care. Bye-bye.